And welcome to Law&Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. We want to start off in Idaho, where Bryant has pleaded guilty to the rape and murder of 18-year-old Angie Dodge 25 years ago, back in 1996. He admitted that he planned to sexually assault her, but not to kill her. He said, "I guess it just happened when I was there." He even remarked that he doesn't remember slitting her throat. Now, this is a man who wasn't arrested until 2019 when genetic genealogy linked him to the crime. In fact, another man, Christopher Tapp, was arrested, convicted, and sentenced to 30 years to life for the crime that he didn't commit, and he wasn't released until 2017. Now, I want to start with Dodge himself. You're going to hear him during his allocution. This is a speech that he presented to the court. Take a look.
Count one, as set out in the information, is a charge of murder in the first degree. How do you plead?
Guilty.
All right, tell me what you did, which makes you guilty of this charge.
Well, I was with the murder one. All I really know is what I told the detectives that night in the interrogation was I went over there with the intent to just rape her. I was pretty high on cocaine and alcohol. I had a pocket knife with me, and I just remember for all occasions just a slap upside my head, and that's all I really remember. I didn't mean to murder her. I didn't think I did, but I guess it happened. I do remember. I remember more of the. I remember. That's about all I remember for the first charge, I guess. But because I went over there, like I said, with the intent to just rape her. But I didn't, and I didn't mean to murder her. I guess it just happened during the.
Your Honor, for the purpose of the allocution, I would ask if Mr. Drips can recall what he did with the knife. I don't think we have that part, and I think there's some additional details during the interrogation that he remembers at least part of that.
All right, Mr. Drips, part of the question, part of the allocution is in what manner, what did you do with your pocket knife?
I don't really remember much. I might have hit it to the neck, but that's about all I can remember.
Do you remember cutting the victim's throat?
No, sir.
Do you deny that that occurred?
I don't deny it. I mean, I can't remember it though, but
Ms. Quinn?
Yes, Your Honor, that's sufficient.
Based upon the statements of the defendant, the court finds the defendant understands the nature of the charges against him and the consequences of a guilty plea. The court finds there's a factual basis for the plea and that it is being made freely and voluntarily. I'll therefore accept that. Direct the clerk to enter that guilty plea. We'll set this matter for sentencing. I will order a pre-sentence report on this as well.
Some chilling words right there. Okay, let's break it down. Joining me today, Law&Crime legal analyst Imran Ansari and criminal defense attorney Silva Mergadician. And great to have you both here. And Silva, it's good to see you back here on the program. Imran, I want to start with you. You have a guy who was seemingly free for years. They had another guy in custody. They had another guy who was serving time. He gets released, and now they ultimately apprehend him. Why do you think now he decided, Mr. Drips, to plead guilty?
Sure, Jesse. Well, they had the pretty conclusive DNA evidence regarding this individual, and it was a long time coming. He had a good stint, if you will, of freedom when he should have been behind bars. And what's really shocking and somewhat an egregious side story in this is the fact that someone spent a significant amount of time behind bars for a crime that he did not commit. So, in essence, this is really justice at play. He's taking responsibility for this crime. He's taking the plea. It's a negotiated plea of, I think, 20 to life. He's going to be sentenced on this. And he's no longer denying that he murdered this individual. So it's been a long time coming, but the DNA evidence was pretty conclusive. And I think, they got a match off the cigarette butt to the crime scene. And I think the plea was a long time coming.
Okay, well, here's the problem, Silva. Not only do you have a guy who brutally raped and murdered a girl back in 1996 and left the family wondering, but he allowed another person to basically serve his prison sentence, okay? And now you have him, and he's taking this deal where he gets the minimum of 20 years in prison, maybe life, death penalty taken off the table. Christopher Tapp, who served the sentence, he got 30 years minimum. And then you see this thing that Mr. Drips might be imprisoned in what's quoted the best suited Idaho Department of Correction medical facility in order to treat his issues. Is he just getting the best deal, or am I not looking at it the right way, considering what he did?
Well, I think, Jesse, that all your points are valid. The problem is in this justice system, not everybody is satisfied by what happens. Imran is right, though. Justice was served. The unfortunate thing also is another man, through a coerced confession, is what it looks like. Thankfully, he was exonerated recently in 2019. But in situations, especially when there's a plea deal where the defendant is avoiding trial, he does get certain benefits. One benefit, absolutely, like you said, removing the death penalty. The second benefit, maybe being placed in a facility that's not as ridiculous or ugly in its form. So yeah, by pleading in this way, by giving this voluntary waiver, by also saying, look, I don't really remember murdering her, but I'm willing to take the fall for this, that does give you certain benefits when you plead like this. So yeah, you're right. But at the same time, justice is served for those families who finally have the right person behind bars, feasibly for the rest of his existence.
And let's talk about the fact that Christopher Tapp, he sued the police department and Idaho Falls for wrongful conviction. It seems that this is a prime case where he should be rewarded for what ultimately happened. But how does that play out, Imran?
Yeah, no. So, Jesse, I think, obviously the plea and the closure for the family and getting the right guy behind bars is a big story. But to me, what's really the more problematic story here is the fact that Christopher Tapp spent all that time behind bars and what appears to be a coerced confession. And I think that is what we take away from this, that there are certain police tactics or techniques that need to be reviewed, that they lead to the wrong people sometimes spending a significant amount of time behind bars, and they lead to some injustice. And we have someone who was interrogated, confessed to a crime that they did not commit, even implicated some other people who I understand were ultimately not tied to the crime, all under the pressure of law enforcement with a seemingly coerced confession. I think he should be rewarded for all that time he spent behind bars. A civil suit is appropriate in this case, in my opinion. And I think that's something what we really have to take away from this, is that justice and law enforcement sometimes needs to be checked. The procedures that are employed sometimes need to be checked. And we have the right person behind bars, but unfortunately, there was a collateral toll with that process.
It's a sad case and a unique case when you have Gayle Dodge, who's Angie's mother. She was actually petitioning and fighting for Christopher Tapp's innocence. That's the case that we're dealing with here. And just to focus a little bit more on the Dodge family, we also heard from Tyler Dodge, who was Angie's nephew. Take a listen to what he had to say.
It's been a burden that we've carried for a long time. It's been 25 years since we lost my Aunt Angie, and we're happy with what's transpired today. There is a lot of value and a lot of wisdom and finality and conclusion, and I think that's what we've gotten today. We are grateful for those that have worked on this case, that have helped it come to this conclusion. We are looking forward as a family to healing and to writing the next chapter of our lives. Thank you.
Silva, when you look at this case, the first thing that strikes you is the similarities to a lot of these cold cases that are being solved through genetic genealogy. Same thing that we saw with the Golden State Killer. Walk us through, the impact that this new form of detective work, this new form of investigation, this new science is able to solve these crimes that we once weren't able to solve, and what impact do you think it's going to have in the future?
Well, it's been incredible. And that's the difference between, let's say, a coerced confession and actual science. Science will not get it wrong. And if done correctly, if the specimen is not corrupted, that's why it's so important that there's proper training to keep these specimens clean so that the DNA evidence will be conclusive. More and more, we're seeing that these cases are being solved. I mean, you look at all of these Netflix shows where serial killers had gotten away with so many murders. You're not going to see that anymore because of the scientific advances behind DNA evidence and the conclusiveness of it. I mean, we always say the defense has the right to have an expert who can testify against the scientific evidence. But again, done correctly, it really does remove a major aspect to a criminal defense. And again, for the parents to have this type of assurances that this, in fact, is the guy and he is taking accountability, we really do have to thank the science behind it for really solving this murder so far in advance. And unlike human error, again, DNA evidence doesn't lie.
Imran, I'm confused about something, though. You have this guy who pleads guilty to his crimes, yet he doesn't remember details. He doesn't remember killing Angie. What's that about? Does he legitimately not remember? Do you think he's just trying to spare those gruesome details from the public, from the family? Because do we take his word for it that he doesn't really remember this?
Yeah, Jesse, during the plea allocutions, that's something what sort of stuck out at me. Is the fact that he does not recall the actual murder, although he is pleading guilty to that crime. And that's why the judge went back to the prosecutor, asked her to present any sort of opinion or questions regarding his memory or his ability to allocute to this plea, and whether she was satisfied, whether that the statement that he made would support the conviction. The judge found it to be satisfactory. He does not deny that he killed her, although he does not recall it. So that was something which I think on appeal, if someone wanted to tack that down the line, that could be some ground. But I think that this was probably well discussed between defense counsel and the prosecutor. They probably have it nicely in writing. And the allocution there is that although he does not recall, whether because he was so high or drunk, he does not deny. And that's why I believe that his plea, if it was attacked for some reason down the way, and he may be signing a waiver of appeal along with this plea, I would imagine, but it would not stand up. I think this was a free, voluntary plea, and it's going to stand up.
Silva, I want to ask you one last question before we hit our break. We have about 30 seconds. Were you surprised that he ultimately took this plea deal? Because if you look at his case, there was a whole issue. I'm talking about Mr. Drips. There was a whole big issue about did he actually confess to this when he was with police, or was he not properly or did not properly understand his Miranda rights? There seems some ground there to put up a really strong defense, and they chose not to do that. When you look at that, were you surprised that he ultimately pled guilty?
Yes, as a defense counsel, but I think there's something huge that needs to be understood. Defense counsel can lead our client to take certain procedural directions. But at the end of the day, the defendant, the client makes the decision. And he decided he wanted to take accountability regardless of the weaknesses of the case.
Yeah. All right. Well, look, he's going to be, Brian Drips is going to be sentenced on April 27th for a crime that he should have been convicted and sentenced to many years ago. We're going to take a break. When we come back, we're going to focus on new findings in the Kobe Bryant helicopter crash. We'll be back.
I can't imagine how difficult today must be for you, and of course, every day since January 26, 2020. So my heart goes out to you. And I'll get into this later, but after today, today is just the beginning of the board's action to improve safety, improve aviation safety, and to ensure that a similar accident doesn't occur again.
And that's a member of the National Transportation and Safety Board, and the NTSB has concluded that the pilot of the helicopter carrying Kobe Bryant, his daughter, and several others, which tragically crashed and resulted in the deaths of all on board, that he suffered from spatial disorientation. These federal officials determined that the pilot, Ara Zobayan, flew into foggy conditions when he shouldn't have, and he wasn't able to see. They even said that Zobayan may have pressured himself to finish the trip quickly. This was something we've been waiting a long time to hear. And Imran, I start with you. Big breakthrough here. The idea that it wasn't mechanical failure, something to do with the helicopter, but pilot error, pilot mistake, pilot doing something that he shouldn't have. Your reaction?
Yeah, in terms of the lawsuit and the legal proceedings that are accompanying this tragic accident, I mean, it has bearing because this individual was an employee of the helicopter company that is ultimately on the defense side of a lawsuit. I think it's going to have bearing in terms of the liability question there, in terms of how he was trained and what sort of procedures they had at this helicopter company. We know he was a seasoned pilot. This wasn't his first time, taking a helicopter up there. In fact, he was Kobe Bryant's usual pilot, if you will. But it's going to be, in terms of it not being a mechanical failure, well, that rules out a lot in terms of what an argument can be on both sides of that lawsuit. And I think it puts a liability question pretty firmly on that helicopter company, and also how and what procedures or training they implemented in terms of this pilot and how they operated their company.
A lot of things to break down there. Silva, I'm going to turn to you on this because as Imran was saying, that Vanessa Bryant, the widow of Kobe Bryant, mother of Gianna, sued Zobayan's estate and the companies that owned and operated the helicopter, claiming negligence, wrongful death. The families of the other victims have sued the helicopter companies as well. And basically they didn't train, they didn't supervise Zobayan as they should have had. And now we're dealing with this conclusion. So if you are representing the state of Zobayan, you're representing the helicopter company, what do you do? What's your defense? Is this conclusion by this independent federal agency the end-all, be-all for you, or do you get a second opinion? How do you defend this when the NTSB just said, in our conclusion, it was the pilot's fault?
Absolutely. The defense will have to get their own expert to counter what the NTSB found. What's really bad for the defense team is the two aspects that the NTSB found. The first, of course, he ignored specific safety measures. He ignored putting in weather conditions in the control panel of the helicopter. And Jesse, I'll tell you, that day of the crash, I actually live in Woodland Hills, California, and I was actually walking my dog. I did not see Kobe's helicopter, but I saw a rescue copter flying towards Calabasas. We live about 15 minutes away from there. And I remember turning to my husband and saying, God, it's a really foggy day for a rescue helicopter to be flying. Something must have happened. And the other aspect to this is the pressure to perform. As a defense counsel, I would say, look, he had 8,500 hours of flight experience. He was flying over 10 years. Kobe trusted this man to fly his children, even without Kobe present. And there was a lot of pressure, whether it be internal pressure, meaning that the pilot felt that I cannot disappoint this man who trusts me with everything, or external. Was Kobe saying, look, man, no matter what, I need to get there. There is a tournament. We need to be there. Although there's no evidence of that, as defense counsel, I would grab on that, saying that because of the pressure, his number one person that he has to make sure is satisfied is Kobe, when in fact, the number one thing that should have been adhered to are the safety measures that federally cannot be ignored. So it's great for again, for the families of the victims, you can't say great, but at least it's very good for them to get some sort of assistance and help financially for the loss, and really bad for counsel that's representing the helicopter company and pilot.
Let's continue a little bit more with the NTSB from their findings about what caused the crash. Take a look.
The pilot was certificated, current, and qualified to fly in visual flight rules in accordance with federal regulations and company requirements. He had about 8,577 hours flying experience, which included about 1,250 hours in the Sikorsky S-76 series helicopter and about 75 hours of instrument flying time. There was no evidence of any pre-existing medical conditions and no evidence of acute or chronic sleep loss. After gaining employment with Island Express, the pilot completed all required company training, including Sikorsky S-76 ground and flight training, which contained modules for aeronautical decision-making and judgment, instrument procedures, unusual attitude flight, procedures for recovering from inadvertent entry into instrument meteorological conditions, and spatial disorientation. As the chief pilot, he held the responsibility of supervising and training all Island Express pilots. Upon advancement to check airman, he gained the additional responsibility of evaluating Sikorsky S-76 pilots during their annual proficiency and line checks. Island Express contracted with an outside training vendor that reinforced the ground and flight training using the company's helicopters. Per company policy, pilots were to fly no lower than 300 feet above ground level, with 500 to 1,000 feet above ground level recommended as a minimum altitude. Company policy identified 1 nautical mile as the minimum visibility when operating in uncontrolled airspace. These company minimums were more conservative than the Federal Aviation Regulation Part 135 helicopter altitude and visibility minimums. Company policy stated that all flights were to be accomplished in accordance with federal regulations and required pilots to obtain a weather briefing from the approved weather sources, and in the absence of that, by whatever sources are available. About 2 hours before his departure from the John Wayne Orange County Airport, the pilot completed a flight risk assessment that was consistent with weather forecast available at that time. The flight risk assessment fell into the low risk category and required no further actions. The pilot developed a plan to avoid forecasted clouds by flying east and north of downtown Los Angeles and filed a company flight. During the climb and subsequent descent, the pilot communicated with air traffic control on numerous occasions but did not declare an emergency. The excessive speed, entering the clouds, the rapid rate of climb, and the left turn were inconsistent with his training.
Imran, still speaking about the defense as we listen to these conclusions, the pilot's brother says that Kobe Bryant assumed the risks of flying, that the victims don't deserve, that they're not entitled to any damages whatsoever. That's one argument. You also hear the helicopter companies who previously said that this couldn't be controlled, it was an act of God. I'm not sure that argument's going to hold water, but the idea that the passengers assume the risks of flying, is that argument still hold for Zobayan's estate and maybe the helicopter companies?
Sure, Jesse. I mean, there is always a risk to something like flying or taking a public transport or things like that. There's a risk in everything in life, but if it's inherently dangerous or not inherently dangerous, then that assumption of risk argument either succeeds or fails. Here, I don't think it's successful. So they relied on the expertise of this pilot. They relied on the expertise of this helicopter company. And I think what we get from the NTSB is that the helicopter company may be in better shape than the estate of the pilot itself. It appears that he did follow the guidelines while he was at least preparing for this flight, but he made a judgment call himself while he was mid-flight to accelerate and go into those clouds and or fog. I think that is the action. That is the act which could be the libel act, if you will. However, we have a pilot who's deceased. We have a case where the parties are arguably deceased, the best witnesses, if you will. So I think that this will ultimately end up in some sort of settlement and not trial as the sort of liability question gets hashed out.
Because we're running out of time on this topic, but I do want to ask you one more question about this. the helicopter companies, seemingly to protect themselves, insure themselves, they've countersued two FAA air traffic controllers, saying that they created a series of erroneous acts and omissions that helped contribute to the crash. Does that go out of the water now, considering that what we just heard from the NTSB? We have about 30 seconds on that.
Sure. Yeah, no, Jesse, not necessarily. Like, we have to see exactly what they're pointing to in terms of possible contributory negligence by these air traffic controllers. Did they give this pilot enough warning? Did they provide enough information to this pilot as he was traveling into that area? I think from the NTSB findings, we don't find any real discussion from that. So based on what we can take from this, I don't think that they will necessarily succeed on that argument. But you have to bring in all the parties and mitigate your damages in the civil case, and that's what they're doing.
And that makes sense. And Silva, I wanted to just come to you with one final question about this. The Kobe Bryant crash aside, now that the NTSB has come out with these conclusions, what kind of legislation, what kind of guidelines should be enacted to prevent this from happening again? Because that is something that the NTSB does. They have no enforcement action, but they do provide these kind of guidelines, advice on how to prevent this from happening. So what do they do?
There were two issues that I saw huge with the press conference, Jesse, that it reminded me that legislation is likely going to change. The first was, I guess this helicopter was usually flown by two pilots. And the interesting thing about spatial disorientation is that usually if one pilot feels it, that's why you have the other pilot who's able to stabilize the copter. So I do have a feeling that maybe the FD, they will look further into that. And the second aspect is mandating that pilots absolutely put updated weather conditions when they are flying and not, again, you have to use what you have and the tools in that copter to guide you accordingly. It's just such a massive fail from the pilot. And the unfortunate thing is the pilot lost his life too. There wasn't intent here. It was just human error.
It's sad. It's sad for everyone that was on board, and it's sad for all the families and people that were affected by this. Just a tragedy, and we're going to continue to follow this case. But we have to take a break. When we come back, we're going to switch gears, update for you in the Ghislaine Maxwell case. Stay tuned. And welcome back, everybody. So here's an interesting thing that we're going to talk about, and it's about Ghislaine Maxwell. The former associate of Jeffrey Epstein is not having a great day again because, as you know, she is criminally charged with allegedly recruiting minors for sexual abuse and then lying about it. And her trial is coming up in July, and she just took another blow because a judge has ruled that certain redacted portions of her deposition from a 2016 civil lawsuit can now be made public. According to Judge Preska, any private interest she has in sealing this portion of testimony does not outweigh the presumption of public access that attaches to it. Silva, let's break this down for a second. Why is this important? If I'm just following it, why is it important that this excerpt can be made public? And why does Ghislaine Maxwell not want it to be made public?
Well, her counsel made it clear that they thought that parts of it were really embarrassing. And the judge covered that by saying, look, what happens between consenting adults will be kept private because it's not really relevant in this case. But when it comes to actual evidence and statements made, it's hurtful. I mean, you can tell when you read the deposition how she answers the questions. Ms. Maxwell, she's very intelligent. She is able to kind of skew her answers in a very professional way. For instance, they were talking about a doll, a puppet almost, that was used with Prince Andrew. And she kept on calling it a caricature. So a lot of it is damaging in that it shows that she was in concert with Epstein in some capacity when it came to providing him with females. And it does hurt her defense. There's just no two ways about it. So of course she would want that blocked. It's best that she remain silent, and everything that she said concerning this through deposition also remain silent.
And this is not her last bite of the apple, right? Because U.S. District Judge Allison Nathan is the one who's overseeing her criminal case, and Judge Nathan can decide what part of the deposition can and cannot be used. What do you expect from this judge in that case?
I actually do strongly believe, even without my defense goggles on, I do believe that it will be allowed in. It's a legally done deposition. I don't see that her need for privacy rises above the need for factual evidence in the trial. I do think it's going to be allowed in. I don't see how defense counsel can get away from that. I just don't see the argument. They're going to argue again that this is not relevant, that it is private, that it is a deposition that should not be made public. Again, I just don't think when you balance the two sides, that that's enough to keep that deposition out of evidence.
As time keeps going on, as July keeps approaching, the question is, will we see a plea deal? Will something be worked out? I don't know. There's still got some months between now and then, and we'll wait to see. But I do want to switch gears and focus on another high-profile individual. You might have heard about this, and it concerns Paris Hilton. Because Paris Hilton testified at a state Senate hearing in Utah about allegedly being physically and mentally abused when she was a teenager at the Provo Canyon boarding school. Really disturbing allegations here. And she's pushing for legislation to promise more oversight over these institutions, even at a federal level. To give you a sampling, here's a portion of her testimony in case you missed it.
Provo Canyon School excuses their abusive behavior by saying they are now owned by a new company, Universal Health Services. UHS, you can't silence me. After conducting extensive research, we found out that while this facility was indeed sold after my time, the practices used and the staff employed remained and remain today the same. One staff member would brag to other students that she was the one who broke Paris Hilton. Violating confidentiality is not only unethical, but also a violation of HIPAA. This woman was employed by Universal Health Services for 20 years. She was let go this October, only after my documentary premiered. I tell my story not so that anyone feels bad for me, but to shine a light on the reality of what happened then and is still happening now. The people who work at, run, and fund these programs should be ashamed of themselves. How can people live with themselves knowing this abuse is happening? Right now in Utah, there are thousands of children experiencing abuse that do not have access to legal counsel, advocacy, or their family and friends, and who are counting on us to do the right thing. We, all of us, have the opportunity today to lead by example and make a difference in saving children's lives. I'm calling not only on the people in this room, but also elected leaders like Representative Scott, Senator Schumer, Speaker Pelosi, Vice President Harris, and President Biden, and everyone listening to my voice today to denounce child abuse.
You're hearing some really powerful words and very strong accusations. Imran, what happens next?
Well, I think, she's made a pretty powerful statement that there should be government oversight and legislation that really checks these schools and these institutions and makes sure that children are essentially not put to abuse, not put to a certain, conduct or implementation that is abusive or dangerous to them. And I think Paris Hilton really made a compelling statement there at the Utah State Capitol, and also called on the federal government to act on this, to have oversight and legislation to make sure that these institutions don't go unchecked, that they aren't allowed to implement certain things that are harmful to children when they should be trying to help children. So I give a kudos to Paris Hilton for getting out there and getting this message out, because I think it's something that's not necessarily on the public radar. You don't necessarily think about these boarding schools and these institutions. And she's put it out there. And I think she has at least the state government in Utah looking at this pretty seriously. And she's called on the federal government to likewise look at these institutions, look at their policies, and think about whether legislation and laws should be enacted in order to make sure that they follow certain codes of conduct that are not harmful to the children who are at those schools.
And Imran, to follow up, what about criminal charges here. Based upon what you've seen in this case and the allegations that have been asserted, is there anything that can happen at that level?
Sure. Well, some of the allegations that Paris Hilton discusses, and if you go through them, they do rise to a level, arguably, that constitute abuse, and not just abuse on a civil sort of definition, but abuse on a criminal definition also. So whether law enforcement in Utah with this particular school or law enforcement in whatever jurisdiction that one of these schools may be in and may implement some of these procedures or practices, they could be on the radar now of law enforcement. And when someone comes to them with a complaint that a child was abused and put forward to sort of conduct and actions that rise to the level of criminality, I wouldn't be surprised now that it is on the radar, that they would look into this. And yes, if someone is abused, put into restraints, physically, emotionally, traumatized, those actions could arise to a level of criminality, and arrests could possibly be made.
And you know what's interesting, Silva? We see this. We see the efforts for criminal justice reform being made by Kim Kardashian, these people with really high profiles, a huge megaphone to speak to the world. This might not have happened. They are able to do something, right, that lawyers and private citizens and ordinary citizens might not be able to do. So as much as people, can criticize someone with a large following or TikTok, all this, it really does serve a public good when you're able to channel that and bring awareness and attention to these issues. And I'm curious what you think about that, being a lawyer and being in this kind of capacity of trying to make change.
Yeah, absolutely. I think when you do have that megaphone of influence, you can bring to light. I mean, again, look at women who stood up against sexual aggressors. The high profile women that spoke out really brought a cause forward when it came to sexual abuse. I mean, look at Larry Nassar and the famous gymnast who came out. Look at the sexual harassment issues that we've had. The louder the presence, the louder the voice, if you will. In California, we've been lucky, though, when it comes to legislation about these kinds of camps or placements or boarding schools. That has been pretty much terminated, especially when it comes to juvenile delinquency in California. Things have really changed dramatically where, using physical punishment against children in a restrictive fashion, whether it comes from boarding schools or rehabilitative centers, is over now. And I think, again, just like Imran said, Paris did do a phenomenal job painting a picture of what this type of physical and mental abuse, what it can do to a young person, and how you still carry the scars from it. Because I think it's pretty clear she's not getting anything from this exposure. She's opening herself up to a lot of people's criticism. Why didn't she speak out earlier? So I think she had a lot of courage, and it does shine a light. And these places are going to be a lot more careful in how they train their instructors on dealing with children.
Well, she called out the new Biden-Harris administration. The question is, were they listening to her? We'll wait and see. We're going to take a break. When we come back, we're going to focus on a tragic story that really, really is so sad about a grandfather who was charged in the death or negligent homicide of his granddaughter. We'll be back. And welcome back, everybody. Salvatore Sam Anello has been sentenced to 3 years probation. This is the grandfather who pleaded guilty to negligent homicide when he was supposed to be watching his 18-month-old granddaughter, Chloe, on a Royal Caribbean cruise ship, but she fell through a window on the 11th floor, plummeting to her death. And as part of this deal with Puerto Rican prosecutors, not only will he not serve any prison time, but he's also going to serve his probation in his home state of Michigan. Let's take a listen to what Anello had to say about what happened.
It's our fault. And I was just in disbelief. I was like, oh my God. And then I just remember screaming that I thought there was glass.
Walk me through what you remember.
All right. So she's down at looking at out the window in the glass. I bent down by her, and then we always, like when you're whenever we're at hockey games, we would bang on the glass, and it was fun, you know. So when I knelt down to be with her at that level, I couldn't reach the glass really, only with my fingertips, so I knew she couldn't. So that's when I decided I'd pick her up. So I, was trying to stand her on a railing, and it happened in seconds.
Imran, this is a awful case. This is an absolutely awful case. And now we see a conclusion. What do you think of the conclusion for Mr. Angelo, given everything that we know about what happened? Do you think this is I don't want to say the best conclusion possible, given what happened, but given the family and what really transpired, is this the best case that they could have hoped for?
Jesse, I never agreed with this prosecution. When the news came out, just generally about what happened, it was shocking, it was saddening, and then it was followed by the news that this grandfather was being criminally prosecuted for this act. I never agreed with it. I think it was, pouring salt on an already deep and painful wound. I think there was nothing. Yes, it's criminally negligent homicide. It's not an intentional crime, but still, I think it was there was a lack of sensitivity, in my opinion, on the prosecutor's part down in Puerto Rico, and this was something that should not have been prosecuted. I think him taking the plea and getting probation is the family's attempt and his attempt to just seek closure of this and move on from a very tragic family experience. Of course, they do have the lawsuit against the cruise ship company for what they are alleging to be negligence on their part regarding this window. But in sum, Jesse, I just don't think that this grandfather should have been prosecuted. I think this was a deeply painful thing. And I mean, I can't even imagine it, what that family was going through and the pain and guilt that he may feel inside. So it's closure, at least on the criminal side for this. And let's see what happens with the civil suit.
And let's talk about that. Silva, this lawsuit that the family has filed against the Royal Caribbean Cruises, saying, why on earth would you have this open window on the 11th floor? And there was a back and forth about whether or not Angelo knew that the window opened or not, and was it his fault? Your analysis on if that's a strong lawsuit and what could ultimately result from it?
Well, first of all, it's an absolutely strong lawsuit against Royal Caribbean. I mean, the issue is also, they said it was for ventilation, but this was an area with children. I mean, you need ventilation in hotel rooms on the 100th floor, but we always see those windows are bound. I do think it's going to be very difficult for Royal Caribbean to defend itself in such an emotional lawsuit. And Imran is absolutely correct. The prosecutors really missed an opportunity to have supreme compassion. This man has already been punished in the worst way that anybody has ever been punished. He lost his beloved granddaughter. According to the family, he is inconsolable. And the fact of the matter is, I wish they took this in front of a jury, because no jury would have convicted this man of anything if he was on the stand testifying to the loss of his daughter. Nobody believes that this man, from what the family is saying, that he believed that that window was open. He had taken this young girl to hockey games. He assumed the window would be closed. And I do think it's highly negligent of what Royal Caribbean did. And again, I cannot see them winning in this lawsuit.
Right. And Kimberly Wygant, who's Chloe's mother, said there are a million things that could have been done to make that safer. I remember when I first heard this case, it was really impossible to make sense of why this happened and who was at fault. But at the end of the day, you have a family who is grieving. You have a grandfather who is not in prison. As you said, he suffered the worst punishment. And as both of you said, we'll see what this lawsuit ultimately brings. Imran Silva, I appreciate you taking the time. Everyone out there, thanks for joining us here on Law&Crime Report. We'll be back tomorrow, 12 p.m. Eastern.